Hi everyone, welcome back. So this is cyber laws problems and solution continuation, and that is part 3. Now the next topic from which we have a problem is dishonestly receiving stolen computer resources, etc. So Mr. A has purchased a stolen cell phone or computer worth 50,000 for 2,000 where he knows that it is stolen property. Explain the nature of offense committed by A. A is liable under Section 66B of Information Technology Act. Section 66B of Information Technology Act. The essential ingredients of the Section 66B are whoever dishonestly receiving or retaining any stolen computer resource or communication device and having knowledge or reason to believe that the said computer resource or communication device is a stolen one. Section 66B aims at punishing those who dishonestly receive or retains any stolen computer resource or communication device, knowing or having reason to believe the same to be stolen computer resource or communication device. Now the next topic we have is theft of identity, that is person's identity. Here Mr. A has cloned ATM card of Mr. B and withdrawn rupees of 1 lakh, whether the act falls under definition of theft of identity. So here the relevant section is section 66C of Information Technology Act that deals with theft of identity. Now the relevant case law is CBI versus Arif Azim 2003. CBI versus Arif Azim 2003. This was the first case in which any cyber criminal in India was convicted. So this was also the first case in which any cyber criminal in India was convicted, and this is CBI versus Arif Azim 2003. Section 66C covers the fraudulent and dishonest usage of the electronic signature, password, or any other unique identification feature of any person. Now, the next topic is cheating by personation by using computer resources. Here, defendants were operating a placement agency involved in headhunting and recruitment. The defendants sent emails to third parties representing NASCOM in order to obtain data which they could use for the purpose of headhunting. So here the relevant section is 66D of Information Technology Act 2000. Section 66D provides punishment for a person who by use of computer resource or computer device cheats another by pretending to be some other person. And the relevant case law is the Delhi High Court in National Association of Software and Services Companies, that is NASCOM, National Association of Software and Service Companies, NASCOM versus Ajay Sood, that is in 2005. NASCOM versus Ajay Sood. So we also discussed a similar case earlier that was also against Ajay Sood in the previous part. Now here we are discussing about NASCOM versus Ajay Sood. Here the defendant, so the Delhi High Court restrained the defendants from using the trade name or any other name similar to NASCOM, and also restrained the defendant from holding themselves out as being as associated with NASCOM. The Delhi High Court declared phishing on the internet to be illegal act entailing an injection and recovery of damages. Now, cheating by personation by using of computer resource, it requires whoever, by a deception of any person, fraudulently or dishonestly inducing that person by personation to accept, agree, transact, or deliver any data, information to any person, or to consent that any person shall retain any data, information, etc., or intentionally inducing that the person to do or omit to do anything which he would not do or omit if he were not so deceived by such personation using any communication device or computer resource. So here the main components is like whoever whoever does the following act is liable, and the act shall be by deception of any person, and this deception shall be based on fraudulently or dishonestly inducing the other person by personation. And what are the acts to be performed? That is, two categories are discussed here. The first category is to accept, agree, transact, or deliver any data information to any person. That is the first category. Or the second category is that to consent that any person shall retain any data information, etc. Now, here how should it be? Intentionally inducing that person to do or omit to do anything which he would not do or omit if he were not so deceived by personation. And how this is carried out is, the means of carrying out this is using any communication device or computer resource. So this is what is discussed in section 66D of Information Technology Act 2000. Now another problem here, Mr. A misrepresented himself to be a reputed person. Mr. C, either by using any communication device or computer resource, and enters into the e-contract with Mr. B. So here Mr. A is liable under section 66D. So what did he do? Mr. A misrepresented himself to be a reputed person to Mr. C. So the means how he misrepresented was using communication device or computer resource, and enters into e-contract with Mr. B. So A entered in contract with Mr. B but misrepresented himself as Mr. C using any communication device or computer resource. So that was the offense committed here, and that comes under 66D, that is of cheating by personation by using of computer resource. Now the next is fake profile on matrimonial social networking site. Is that an offense? So intentionally creating a fake profile on matrimonial social networking site like Facebook, YouTube, etc., and microblogging sites like Twitter, Instagram, etc., with an intention to cheat is an offense. So what is the main thing is, with an intention to cheat is an offense. Now explain with relevant section. So here also section 66D is relevant, and here creation of a clone website to capture personal information of a user amounts to cheating. So here also the relevant section is section 66D of Information Technology Act. And the next topic is internet banking frauds. As per which section, internet banking frauds involving blocking or duplication of mobile SIM cards or misappropriation of customer ID, corporate ID, or user ID is an offense. So this is a question, as per which section internet banking frauds involving blocking and duplication of mobile SIM cards or misappropriation of customer ID or corporate ID or user ID is an offense. So here the theft of identity as well as cheating by personation can be made applicable. That is section 66C, which deals with theft of identity, and 66D, which deals with cheating by personation by using of computer resource. So 66C and 66D of Information Technology Act 2000 can be made applicable in this scenario. The next one is violation of privacy. Violation of privacy may include installation by spy cams, hidden cameras, communication device inside washrooms, bedrooms, changing rooms, hotel rooms, etc. for the purpose of violating bodily privacy of any user or occupant of such, explained by citing relevant section. So here section 66E can be made applicable. Section 66E of Information Technology Act 2000. Section 66E provides that any person who intentionally or with due knowledge captures any image or publishes in printed or electronic form, distributes any image of a private area of a person without the person's consent, violates the privacy of a person, is punishable with imprisonment that may extend to 3 years or fine not exceeding 2 lakh or with both. The essential ingredients here is that whoever and intentionally or knowingly then captures, publishes, or transmits the image of a private area of any person without his or her consent violates the privacy of that person. So it's immaterial who does it, but the intention or knowledge should be there, and the act should be of capturing, publishing, or transmitting the image or video, and that should be of the private area of any person, and this action should be without his or her consent, then there is a violation of privacy and section 66E is applicable. Now, the next is sting operation fall under section 66E. Okay. The next problem is that whether sting operations fall under section 66E of Information Technology Act 2000. So, section 66E provides that any person who intentionally or with due knowledge captures any images or publishes in printed or electronic form, distributes any images of private area of a person without the person's consent, violates the privacy of a person, is punishable with imprisonment that may extend to 3 years or fine not exceeding 2 lakh or with both. So that is what is discussed in section 66E. So if the sting operation is carried out by a private person or agency which result in violating the bodily privacy of any other person, then such an act would fall under the ambit of section 66E of Information Technology Act 2000. Whatever may be the reason, public interest or the people's right to know, one should not disregard the protection of being given to an individual against his bodily privacy under this section. In a sting operation, if it violates bodily privacy of another person, such a private person or agency conducting any such sting operation would be making itself liable for action at law. Here, in court on its own motion, that is suo motu versus state, in court on its own motion versus state in 2008, the division bench of Delhi High Court summarized its view on sting operation as below. So, in its own motion, the court on its own motion versus state 2008. Here, the division bench of Delhi High Court summarized its view on sting operations as below. 1. A sting operation by a private person or agency is by and large unpalatable or unacceptable in a civilized society. A sting operation by a state actor is also unacceptable if the state actor commits an offense so that an offense by another person is detected. Second one, a state actor or a law enforcement agency may resort to hidden camera or sting operation only to collect further or conclusive evidence as regards the criminality of a person who is already suspected of crime. The third one, the law enforcement agency must maintain the original version of the actual sting operation. Tampering with the original video or audio clips of a sting operation may lead to the presumption of the suspicion of the entire operation. The fourth one, a sting operation cannot be initiated to induce or tempt an otherwise innocent person to commit a crime or entrap him to commit a crime. The fifth one, normally, if a private person or agency unilaterally conducts a sting operation, it would be violating the privacy of another person and would make itself liable for the action at law. So that was discussed in Court on its own motion versus State 2008, and this was summarized by a division bench of the Delhi High Court. Now, the next topic we have is cyber terrorism. Mr. A unauthorizedly accesses any computer resource of railway company and gives direction resulting in mismanagement of routes of rail and causes injury to people. Does this act come under cyber terrorism? So cyber terrorism is discussed under section 66F of Information Technology Act 2000. The term cyber terrorism is a controversial term and proper definition of this term has not been provided anywhere. This section provides that a person commits cyber terrorism if he uses cyberspace with the intent to threaten the unity, integrity, security, or sovereignty of India or to strike terror in the people or any section of the people. A person commits cyber terrorism by 1. Denying or cause the denial of access to any person authorized to access the computer resource, or 2. Attempting to access a computer resource without authorization or exceeding authorized access, or 3. Introducing or causing to introduce any computer contaminant. Now these are three instances that where a person is said to have commit cyber terrorism. Now, a broad analysis of aforesaid section reveals the following three essential ingredients of cyber terrorism. The first one, there must be an intention to threaten unity, integrity, security, or sovereignty of India. The second one, the act committed must include either to deny or causing the denial of access to any person authorized to access the computer resource or access a computer resource without authorization. And the third one, any act which is connected, associated, or related with the terror is covered under this section. Such act must result in death or injury to persons or damage to their destruction of property or damage or destruction of supplies or services essential to life of the community, etc. So, in the instant case, that comes under cyber terrorism discussed under section 66F. So, there is a no clear-cut definition that is given, but an inclusive one is given, including that uh, cyber terrorism is anything that is done on cyberspace that threaten the unity, integrity, security, and sovereignty of India or to strike terror in the people, mind of the people, or any section of the people. Now, the next problem, which is also related to cyber terrorism, that is the fraudsters in a country X. The fraudsters in a country X commits a denial of service act, that is DOS act attack on the servers of the railway service in a country Y, resulting into complete failure of the railway network in country Y, and railway service are completely paralyzed. The country Y claims it to be an act of cyber terrorism committed by the hackers. Discuss the same in context of Information Technology Act as whether country Y would succeed and what are the prerequisites of the cyber terrorism. So just as we discussed right now, cyber terrorism as discussed in section 66F has three main components. One, the act should be in a cyberspace and it should threaten the unity, integrity, security or sovereignty of India. And there must be an intention to the act committed must include either to deny or cause denial of access to any person authorized to access the computer resource or access a computer resource without authorization. And the third one is if it's caused injury to people or damage or destruction of property or damage or destruction of supplies or services essential to life of the community. So railway service is one of the services essential to the life of the community, and it also injures the people when railway services are disrupted or an accident occurs. It causes injury to a vast number of people. So for sure this act comes under cyber terrorism, and country Y can sustain the suit for cyber terrorism because the fraudsters in country X has used cyberspace, and they also committed a denial of service attack, which is also discussed under section 66F. And then it is against railway services of in a country which is in country Y, which is mainly of a generally railway services controlled by the government, so it is against a government service, and it is also one of the essential services essential to the life of the community. So with all these ingredients, section 66F of Information Technology Act can be invoked and made applicable here, that is cyber terrorism. Now another question we have, that is also yet again cyber terrorism, that is in 2611 attacks, the perpetrators did access the computers or computer resources available at the Trident Hotel and Taj Hotel. They accessed the hotel computers to download information about the hotel guests, especially the US and UK citizens staying at that point of time. Their objectives was to kill the hotel guests selectively by obtaining their room numbers from hotel computer database, whether the act falls under the definition of cyber terrorism. So yet again here cyberspace is used. In section 66F, we considered three matters. Here, cyberspace is used, and this access was without authorization and with a malified intention. And this also affect the integrity of our nation because these citizens are guests in our country. They are foreigners and they are guests, tourists in our country. So anything that happens to tourists while they are in our country does affect the sovereignty and integrity of our security of our nation, because it affects the foreign relationship we have with those countries. So here all the components of the, and it is to cause injury to the people, so it is also to cause injury to the people. So all the components of section 66F are satisfied or upheld here. So this also comes under cyber terrorism, that is section 66 of F of Information Technology Act. According to section 66F, the perpetrators intentionally threatened the unity, integrity, security or sovereignty of India and struck terror and caused death or injuries to persons and damage or destruction of property by penetrating or accessing a computer resource without authorization. So, perpetrators, by accessing hotel's computer database, came to know the details of the foreign guest, which they otherwise would not have been able to do so. After obtaining the identity of the guest selectively, they chose their target and caused death or injuries to many of the guests. Therefore, the act's perpetrators of 2611 may fall under the category of cyber terrorism. Now, the next topic we are going to discuss is publishing or transmitting obscene material in electronic form. So, the accused was a known family friend of the victim and was interested in marrying her. She, however, married another person. After her divorce, she received many proposals from him, but every time she refused. The accused started harassing her through the internet. He posted an obscene, defamatory, and annoying message about her in the Yahoo message group. Emails were also forwarded to the victim for information by the accused through a false email account opened by him in the name of the victim. So here, section 67 of the Information Technology Act is uh, attracted or made applicable. So we have a relevant case law here, that is State of Tamil Nadu versus Suhas Katti. State of Tamil Nadu versus Suhas Katti. In this case is a landmark case in the history of cybercrime in India, which is considered to be the first case where the accused was convicted under Section 67 of the Information Technology Act 2000. So once again, State of Tamil Nadu versus Suhas Katti. Section 67 provides the punishment for a person who publishes or transmits or causes to be published pornographic or obscene materials in electronic form, etc. For example, sending an offensive and obscene email, posting defamatory and annoying message, etc. Section 292 of IPC provides that if the transmission, disseminating of obscene information, which is an offense, but mere possession of obscene material for personal use of someone is not an offense under the Act. So Section 292 of IPC provides that if that it is transmission, dissemination of obscene information which is an offense, but mere possession of the obscene material for personal use of someone is not an offense under the Act. The ingredients of offense under the aforesaid sections are: the first one, publication or transmission in electronic form; second one, any material uh, lustful or appeals to the prurient interest. Now, the third one is tendency to deprave and corrupt persons. Fourth one is likely audience. And the fifth one, to read, see, or hear the matter contained or embodied in electronic form. So here section 67 is made applicable, and the first case where there was a conviction under section 67 of Information Technology Act 2000 is State of Tamil Nadu versus Suhas Katti, and section 292 of IPC is also attracted in this case. Now, that is section 67 is related to publishing or transmitting obscene material in electronic form. Now, the next one is exchange of child pornography in electronic form. So that is with respect to section 67B. So section 67, 67A and 67B are similar to each other, and when it is about child pornography, section 67B is attracted. Now, what is the difference is section 67 discusses about obscene materials in electronic form, publishing or transmitting obscene materials. Section 67A, where it is sexually explicit act is transmitted or published in electronic form, and section 67B is where children involved in sexually explicit act is published or transmitted in electronic form. So child pornography comes under section 67B. Now, Mr. A knowingly publishes a notice over the internet offering to exchange child pornography. Comment with relevant case law. So, Section 67B is the relevant section of Information Technology Act 2000 that is applicable here. And the case law, we have a US case law, that is US versus Joseph C. Bledos. US versus Joseph C. Bledos. In the above case, the defendant was convicted and sentenced by the United States District Court for District of South Carolina. So the defendant was convicted and sentenced by the United States District Court for the District of South Carolina at Columbia for knowingly publishing a notice over the internet offering to exchange child pornography in violation of 18 USCA and 2020 to 2251 subclause D. So 18 USCA and 2251 subclause D. He filed an appeal in 2006 before United States Court of Appeals for the Fourth Circuit, which affirmed the convention and sentence. So this person was convicted and sentenced by the district court. He went for appeal and the appeal also was against, not in favor of him. So his offense was he posted an ad online saying to contact him for any exchange of child pornography. So that was the offense committed by him, and that was against the 18 USCA. Now, publishing or transmitting obscene material depicting children in sexually explicit act, that is discussed in under section 67B of Information Technology Act 2000, provides 5 instances of online child pornography that has been criminalized. The first one, publishing or transmitting or causing to publish or transmit material in any electronic form which depicts children engaged in sexually explicit act or conduct. The second one, creating text or digital images, collecting, seeking, browsing, downloading, advertising, promoting, exchange, or distributing material in any electronic form depicting the children in obscene or indecent or sexually explicit manner. So it is to be noted that not only publishing or transmitting or causing such act, but also that collecting, seeking, browsing, downloading, advertising, promoting, exchange, all these acts also falls is an offense when it is respect to child pornography. Now, the third category is cultivating, enticing, or inducing children to online relationship with one or more children for and on sexually explicit act or in manner that may offend reasonable adult on computer resource. And the fourth category, facilitating abusing children online. Now that is also cyberbullying. Now the fifth one, recording in any electronic form on abuse or that of others pertaining to sexual explicit act with children. So these are the 5 instances that falls under that becomes an offense under 67B, capital B of Information Technology Act 2000. Now, Section 67B, subclause A, takes into account all instances of the child pornography using any computer resource and communication device. It criminalizes publication or transmission of any material depicting children in any sexually explicit act in the form of text, image, audio, or video. Any instance of attempted publishing or transmitting or attempted receipt of child pornography is also an offense. Now, there is some exception that of publishing in public interest, etc. that is applicable for 67, 67A and 67B. That is with respect to, for example, we have sexually explicit images in our medical textbook or forensic book or for study purpose, research purpose, the purpose of art. That is excluded from these sections. So, proviso to section 67B provisions of section 67, 67A and 67B do not extend to any book, pamphlet, paper, writing, drawing, painting, representation of figure in electronic form, the publication of which is proved to be justified as being for the public good and on the ground that such book, pamphlet, paper, writing, drawing, painting, representation of figure is in the interest of science, literature, art, learning, or other objects of general concern. So, what is the exemption? If it is for public good or public interest, or for the purpose of science, literature, art, learning, or other objects of general concern, you are exempted from the liability under section 67, 67A and 67B. Now, another category is which is kept or used for bona fide heritage or religious purpose. So, under the proviso, under the exemption, we can consider two categories. The first category is if it is used for public interest or for the benefit of the science, art, literature, learning, or other general concern. Or the second category is if it is kept or used for bona fide heritage or religious purpose. So, for an example, when you go to old archaeological sites, you can see many drawings, or in temples we have statues, which is not fully covered. Some are nude statues, but these doesn't fall under obscenity because they are part of the bona fide heritage or religious purposes. So that these sections are not, and transmission of those pictures are also not for does not fall under any of these sections. That is 67, 67A and 67B. Now, the next problem is Miss A approached the police alleging that some unknown person created her fake profile containing her photograph on the website xyz.com and attached the link I am available, and on clicking the link it takes to the pornographic website containing sexually explicit act. The police claim that offense did not occur in their jurisdiction as the website is not hosted from India and no incriminating act have been done to their jurisdiction. Elucidate remedies available to Miss A for the offense as well as jurisdiction. So here section 67B is attracted, and the police cannot say that the jurisdiction is not affected, and the mere posting itself is an offense. It is not necessary that there should be a further act on it. The usage of her photo without her consent and in such a website itself attracts section 67 A, 67, 67, 67A and 67B. If the person is a child, of course 67B too. Now, the another problem is the adult and child pornography has become a nuisance over the internet, which is accessible to people of all the ages, including children. Elucidates the provisions of IT Act as to the website containing obscene contents and the power of the government to block them. So this is again with respect to section 67, 67A and 67B. All these sections are similar, but the uh, criminal liability or the penalty for 67B is much higher than 67 and 67A. And yeah, or the penalty is different, but the liability is more or less the same. It all discuss about the same matters, or the core subject matter is the same. Now, abusing children online. Children painted on mother's naked body, recorded and uploaded in social media. Okay, so this similar case was there in the news. I think I guess an year back or something, and it was pretty famous back then. So I guess this is based on that case. This question. Let's see. A mother asked her two minor children, aged 14, a boy, and 8, a girl, to paint on her naked body and a body above the navel. The children painted on her naked body. The mother recorded it as video. After that, the video is uploaded in social media with the heading Body Art and Politics. When the mother is liable, whether the mother is liable for punishment, whether she can defend the act, claiming it is part of sex education. So this exact case it's a real life case, and it was discussed about a year ago, and it took place in Kerala. So towards the answer of it, Section 67B, subclause D of the IT Act says that whoever facilitates abusing children online shall be punished. The mother asked her children to paint on her naked body. Thereafter, she uploaded the video in social media. The mother is liable for the following offences punishable under Section 13, 14, and 15 of Protection of Children from Sexual Offences Act, that is the POCSO Act 2012. Section 13, 14, and 15 of the POCSO Act under Section 60 and under Section 67B subclause D of the Information Technology Act 2000, and also attracts Section 75 of the Juvenile Justice Care and Protection of Children Act 2015. So not only is the IT Act applicable here, the POCSO Act Section 13, 14, 15 and the JJ Act Section 75 is applicable here. According to the mother, she is teaching her children sex education by uploading this video. But if the painting done on the naked body of the mother happened inside the four walls of the house of the mother, there cannot be an offense. The mother when shot and uploaded these videos in a social media. She also claims that she wants to teach sex education to children in the society. Thus, this stand of the mother cannot be accepted. Punishment for child pornography. Section 67B provides for the punishment for publishing or transmitting child pornography electronically. Any person that publishes or transmits or caused to be published or transmitted electronically any material displaying children in sexually explicit acts or creates any images or text, collects, browses, downloads, markets, and distributes such child pornographic material or entices children for sexually explicit acts or facilitates child abuse on internet or record abuse caused by himself or others in connection with sexually explicit act with children uh, is punishable with 5 years of imprisonment and fine that may extend to 10 lakh rupees, and in case of second or subsequent conviction shall be liable for imprisonment for a term that may extend to 7 years and fine which may extend to 10 lakh rupees. Now, the provision of 67, 67A and 67B includes such literary works or images in electronic form which are justified to be published for public good. It serves the interest of science if it serves the interest of science, literature, or art or other objects of general concern, or which are retained or used for bona fide heritage or religious purpose. The explanation to Section 67B states that children means a person who has not attained the age of 18 years. Hence, even browsing or downloading of child pornography is an offense, which is not in case of adult pornography. This provides limited freedom of speech in India or reasonable restriction as transmitting or publishing adult content is illegal but browsing or downloading is not. Clause D of Section 67B may be used against the intermediaries, including the cyber cafes, for not taking sufficient due care. Cyber cafes are liable to adopt adequate precautions to ensure that computers installed at their facility are not used for unlawful purpose. So, the liability under Section 60B is also applicable to intermediaries. And in the present case, in the present problem, the mother is liable if it was within the four walls. She could have taken the defense that she was having a sex education for the children, but when she posted it online, she cannot take that defense, and that is not acceptable. Here, POCSO Act Section 13, 14, 15 are attracted. IT Act Section 67B subclause D is attracted, and JJ Act Section 75 is attracted. So that is with this part of discussion. We still have a lot of questions pending, and that will be discussed in the following parts. Thank you all, and do like, comment, share, and subscribe. And let me know if there is any topics that you would like to discuss more problems in, so that I can collect those problems and discuss the solution. And if there is any other subjects you would like to do, you would like me to do problem and solution session, please let me know. If for any feedback, please let me know. And thank you. Have a nice day and take care.